Hi, I'm Anna Denton-Jones of Refreshing Law, and in today's session I want to think about the situation where somebody is off on the sick and you have reason to believe that perhaps the claims that they're making in relation to their health are not true and that they might not be as unwell as they say they are. This came to light recently in a tribunal claim that involved a bus driver who was employed by Metroline, and in that case he had suffered, he said, a slip in work where he had fallen on a wet patch and injured himself to such an extent that he was bringing a personal injury claim against his employer, as well as obviously them having to deal with his employment situation. Something must have aroused the employer's suspicions, and they ended up hiring a covert surveillance team to actually go out and video him taking part in sort of normal day-to-day activities, and they discovered that he was perfectly capable of carrying his own shopping and getting about contrary to what he had been leading them to believe the position was. So they actually ended up dismissing him, not in the ordinary run of things like we might expect, because he was incapable of doing his bus driving duties, but they actually ended up dismissing him instead for misconduct and arguing that he had obviously falsified the position to his employer and claimed things that weren't true, which obviously can be a dishonesty offence. So they ended up dismissing him summarily with no notice, and he brought a claim for wrongful dismissal and a claim for unfair dismissal against his employer. Now, at the original tribunal, the tribunal seems to have got themselves a little bit mixed up between the difference between this sort of conduct strand, if you like, and the sort of traditional capability route that you might bring somebody's employment to an end for if they aren't well enough to return to work. It ended up going to the Employment Appeal Tribunal, and the Appeal Tribunal clarified that the employer was well within their rights to dismiss for this conduct route, provided, of course, normal rules in relation to conduct apply. And you're all used to the idea that you've got to have a reasonable belief that the misconduct as alleged has occurred. And that reasonable belief normally comes around as a result of there being some kind of an investigation. And of course, in this case, the covert surveillance evidence formed part of what the employer was going to argue was a reasonable investigation. They'd also got occupational health reports and assessments and things like that, which obviously went in their favour as well. The case obviously illustrates that there is potentially sometimes this angle. Even though it is a sickness absence case, there will be times where you believe somebody is malingering or trying to pull the wool over your eyes about their condition. We have, of course, always got to be careful. There are always those cases where employees come in and say, you know, I saw Joe Bloggs on the golf course on the weekend, and there's nothing wrong with him. Now, of course, it depends on what the medical condition is. It could be that a GP has said, you know, your depression would be really helped if you got yourself out there in the fresh air, in which case it could be unfair dismissal to dismiss somebody in that regard. But if you had an employee who was perhaps telling you that they were so unwell they couldn't even leave the house, and then we had lots of evidence of them being seen out and about around town, then obviously that's going to potentially undermine what they're saying to you and make you at least suspicious and want to find out a little bit more. If you do have any questions on today's session, please do let me know. It's adenton@refreshinglawltd.co.uk. Thank you very much.